All right, this is 2301408 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his count.
Welcome back to the courtroom chaos, where today's docket features not one, but two sovereign citizen showdowns, and both from the same familiar face, Arnold Chavez. He's battling both JP Morgan Chase and Discover Bank. And let's just say his legal arguments are more Wikipedia than law school. In classic sovereign citizen fashion, Chavez claims he's actually the lender, that the bank somehow owes him money, you know, because personal security and UCC loopholes and strawmen. Nonsense. But this judge isn't playing along. Later in the hearing, he pulls out one of the wildest moves we've seen, trying to represent himself and someone else as a beneficiary executive of their legal name. And just when you think it couldn't get any messier, another sovereign citizen pops up trying to argue that a piece of paper is the actual defendant. This is going to be a roller coaster of delusion, denial, and judicial smackdowns. So buckle up. You don't want to miss this.
To see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure, and make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owed $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
That's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender.
Chavez starts off with the I've been researching the law routine. That's usually sovereign citizen code for I watched YouTube videos at 3 a.m. and now I think I'm a constitutional scholar. He's not denying the debt. He's just questioning the accuracy of accounting records and insists he wants to make sure everything's correct. This tactic may sound reasonable on the surface, but it's often just a stalling move wrapped in pseudo-legal language. The judge, however, is already zoning in on the basics. Did you take the card? Did you use it? Did you pay it? Spoiler, things go downhill fast.
Listen to me. Listen.
It's not about. I have it. This. I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card and you didn't pay on the card. They don't owe you anything.
So so when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. Where did I? 1 second here. I have them.
No, wait a minute. December 19th, you're the problem.
Okay. It's gonna have to be January 9th.
Okay,
My clerk's indicating. So.
I will get that out
motion for
right
summary
away. I had
disposition.
it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
We have officially entered the twilight zone. Chavez just said he's the lender. That's right, not the multi-billion-dollar bank with the credit card account, but him. Why? Because they borrowed his personal security, whatever that means. This is where sovereign citizens often spiral into fantasy finance, claiming their signature or identity was leveraged as collateral and therefore the bank owes them. In reality, courts don't entertain this logic, and neither does this judge, who's already sharpening her legal sword for—
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of. I talked to them in the chat. They confirmed it, and I have they gave me a bill credit for the inconvenience, so that's why I wasn't able to attend because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So, here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
The judge is doing what all judges do when faced with nonsense, setting the wheels in motion to wrap it up cleanly. She schedules a motion for summary disposition. Legal speak for, this case has no merit. Let's fast track it. Even the bank's attorney didn't feel the need to file early because Chavez's defense was that weak. The court's basically saying, come back in January and we'll make this official. But don't worry, Chavez isn't done. He's got another credit card case waiting right after this.
Do we need discovery on this? What, Mr. Gothal, so this is a credit card bill.
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands.
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter in.
Chavez now blames his missed court date on a broken internet connection from Sfinity. And while that might sound like an excuse, it turns out the court actually received communication about it and considers it valid. But here's the problem: even if your excuse holds, you still need an actual defense. Saying you just want to go through the due process doesn't mean you have a case. This is like showing up to a boxing match and declaring you don't plan on throwing any
in the amount of what is claimed in the complaint. $4,378.29 will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more.
And here comes the hammer. The judge rules in favor of Discover Bank, noting that Chavez didn't dispute the facts. He just didn't like the consequences. Sovereign citizens often believe that waving around affidavits, no matter how irrelevant, will somehow void a contract they willingly signed. But courts deal in facts, not fantasy. The judge even highlights how Chavez's own filings prove the plaintiff's case, so no, that homemade affidavit isn't going to save him, even if it's printed in gold ink on
do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it.
Reached peak sovereign citizen absurdity. The man claiming to represent Sherman Moore says he's not Sherman Moore, but merely the beneficiary of that name. This is classic strawman theory. The belief that your legal name is a corporate entity separate from your flesh and blood self. It's basically courtroom cosplay. Unfortunately for him, this judge isn't amused. You can't just disown your identity because you don't like what's printed on the court papers.
And so are you appearing on Mr. Moore's behalf?
Yes,
Okay,
I am, yes, here for that matter to handle the matter that's at hand.
okay. And are you an attorney, sir?
I am the attorney, in fact, for the said name at hand here.
Okay, so you are an attorney representing Sherman Moore?
Yes, I will be handling the case for Mr. Moore.
Okay. And are you licensed by the state of Washington to practice as an attorney?
I am not licensed or a bar member or a lawyer or anything of the such, but I am here as
The gavel drops on another sovereign citizen spectacle. Arnold Chavez walked into court thinking he could flip debt law on its head, claiming to be the lender, denying basic facts, and even trying to represent a piece of paper as a person. But the judge wasn't having it. Both J.P. Morgan Chase and Discover Bank walked out victorious, and Chavez walked away with 2 judgments on record. This case is a masterclass in what not to do when facing debt collection in court. If you enjoyed watching the sovereign logic crumble in real time, smash that like button. Drop your thoughts in the comments, especially if you've ever seen sovereign citizens in action. And don't forget to subscribe. We've got